Good morning to all of you. My name is Bill Neukom. I'm standing before you as the President-elect of the American Bar Association, and I have a brief prepared statement I'd like to make, and then we will have time for you to ask questions and me to try to answer them. There's also in the room with us today several of my colleagues from the association upon whom I may call from time to time if there are matters of precise focus. The rule of law, justice, these concepts only have meaning when we stand up and we protect them. I'm proud of the work of the ABA House of Delegates being concluded now in a room close by. I'd like to invite your attention to three measures that have been addressed here at the San Francisco meeting of our House. Let me start with resolution number 10C concerning the U.S. Attorney's offices. That resolution affirms the American Bar Association's longtime belief that federal prosecutors should be insulated in their daily duties in the exercise of their prosecutorial discretion from partisan politics. It is essential that all Americans have confidence in our system of justice, to believe that federal prosecutors are fairly and impartially applying the law without any hidden or not so hidden partisan agenda. And prosecutors must feel free to serve just one master, the law, without fear of reprisals from partisan political officials. To that end, we will look at ways for the American Bar Association to study this issue, and we intend to make specific recommendations during the coming year on how to achieve the goal of fair and impartial and professional execution of duties by U.S. attorneys around this land. It's fair to say that the resolution was inspired to some extent by concerns over the Justice Department's dismissal of 9 career prosecutors in June 2006. But our concerns in this area of the law are by no means new. The association has had a policy regarding federal prosecutors and partisan influence since the 1970s. Our goal is to offer solutions for this administration and future administrations that will give Americans the confidence they deserve in the impartiality of our justice system. A second important issue deliberated by our House of Delegates involves the state secrets privilege. And the question is whether our federal government should be able to terminate a civil case at the outset, by the simple assertion that it would compromise state secrets if the case were to go forward, without any further explanation and without any judicial inquiry as to the truth of that allegation, that assertion. In a number of lawsuits, including some involving electronic surveillance by the federal government, the government has said that it should have that power. There are two competing needs that deserve to be balanced in the discussion of state secrets privilege. When Americans believe their rights have been violated by the federal government, surely they deserve a day in court to test that. On the other hand, it is important that the federal government have the means to protect our national security. ABA Resolution 116A, we believe, is a measured response to that balancing. It says that judges should fully examine the legitimacy of the alleged state secret claims in a secure setting before deciding whether a lawsuit against the government truly is a threat to the nation's security. When the court finds that it is not a threat, that case should be permitted to proceed for further proceedings. Finally, in a third matter, the House has addressed the troubling issue of torture as a means of gathering information. In Resolution 10B, we call on Congress to supersede the President's executive order that would exempt the CIA from limits on the treatment of detainees. 3 years ago, during our annual meeting here in San Francisco, this House called for an end to torture by agents of the American government. Since then, Congress has declared its clear intent that torture be banned. Mistreating or abusing detainees runs counter to what this country stands for, and it damages our credibility in the world. What's more, leaders of our armed services say it does not produce reliable information, and in fact, it exposes our own troops to increased risk of being tortured. The time for delays and exceptions has come to an end on this subject. The Geneva Accords, which protect our own soldiers and sailors from mistreatment by enemies, are recognized as law by our government. It's time for Congress to make clear beyond any doubt that America will not engage in any form of torture. In the coming year, the ABA is co-sponsoring the World Justice Project, whose goal is to advance the rule of law in the United States and abroad. The resolutions that I have mentioned, these three, illustrate the challenge every country faces in maintaining a just and lawful society. You should have brochures today which describe the details of the World Justice Project. Specific elements all work toward a single broad goal: helping communities and nations all around the world adhere more closely to the rule of law. The project defines the rule of law as having just 4 universal principles, if you will, principles which are universal enough to guide an evaluation of the rule of law in any country, but at the same time have a basic grounding. The first is that a rule of law community will have a system of self-government, a system in which all individuals and the government itself are accountable under the rules, under the law. The second universal element is that a rule of law community must have that system of self-government based upon rules or laws, not upon might, not upon wealth, not upon religion, not upon family connections. Those rules, of course, can't be just any rules. They have to be rules which are fair and just. We all know of regimes based upon rules which were neither fair nor just. Those rules, those laws must be broadly publicized by the government. They must be well understood by the public, which is designing its work and its lives around those rules. And those rules or laws must be reasonably stable. You can't have a rule of the day regime, nor can those rules be effective if they are written in stone and not subject to improvement over time. The third universal element is that that rules-based system of self-government must afford a robust and an accessible process by which parties may enforce their rights and responsibilities, and that they be enforced in an impartial manner. Robust means that when a transaction is structured and consummated, a deal is a deal. It means that when disputes are resolved, that the parties and the community